So is this something that should have disqualified him? Is this something that's going to create an issue for appeal or create a new trial for Derek Chauvin?
Hi, I'm Peter Tragos, host of the Lawyer You Know podcast and YouTube channel. The saying goes, everyone hates lawyers until you need one. Well, I'm here when you need one to answer your questions and give you insight that you didn't know you needed.
Welcome back to The Lawyer You Know. We just finished doing the video on Derek Chauvin's motion for new trial, which centered around the effect that the media attention, the media pressure, the political statements and pressure, the race-based pressure on this jury that was not allowed to be changed in venue and was not sequestered by the judge. And that's why Derek Chauvin says he needs a new trial. So today we're actually going to be able to get into the mind of one of those jurors because he did an interview. So we're going to react to that interview and kind of go through it. And I'm going to do a lot of the thinking, since I am a lawyer, on how I would feel if I was the prosecutor and I won this verdict and I don't want it to be overturned, or if I was the defense attorney and I do want this verdict to be overturned. And I want to use these answers the juror gives in my appellate motions to try to win that appeal. So let's hear what the juror says about how the entire process went and how they all made decisions in that jury room.
So a jury in Minnesota handed down a verdict in one of the most high-profile cases in years in this country. They found former police officer Derek Chauvin guilty of murdering George Floyd. 12 men and women deliberated under intense pressure. And for the first time, we're hearing what went on in that jury room. Brandon Mitchell served on the jury. He joins us this morning. Brandon, good morning to you, sir. Thanks for your time.
So before we get to what Brandon actually says, I want to start out with the first thing that I would use if I was the defense attorney for Derek Chauvin in my appellate motion, okay? Because one of the things I'm arguing is all this media attention, all this craze, these jurors knew they were going to be famous after. They had to do what everybody wanted them to do. They didn't even have a choice to say not guilty. For any of these verdicts, could they have possibly said not guilty because of the media attention and craze, right? That's going to be one of my arguments. So before this guy says a word, what do I notice? He has a sign over his left shoulder that says, "The Wholesome Podcast." So he's promoting a podcast, doing national news media interviews. He knows tons of people are going to watch this, and he's promoting a podcast. So he's using his position as a juror on this really big and high-profile trial to promote something. So if I'm the defense lawyer, I'm going to say, you can get into this guy's head and know exactly what he thought going on to that jury. He knew he was going to do something where he could make money on it afterwards or write a book or do a podcast or whatever it may be. So that's before he even says a word. That's what this says to me, that he is promoting something while he's supposed to be talking about, doing his civic duty, promoting justice. He thinks he got a just verdict in this case, but he is also using it for personal gain, or I don't know whose podcast that is, but for the gain of some podcast of somebody that he knows, I assume, or somebody that paid him to put that up there. Just not a good look to start it. I would have rather not seen that if I was the prosecutor. I would rather see him just come in serious, saying he did his job, saying nothing affected him, and boom, move on. So let's hear what he has to say.
Absolutely. Good morning. Thanks for having me.
Take us inside the jury room. You deliberated for, as we understand it, roughly 4 hours. One of the 12 jurors reportedly was on the fence. Why is that? And what ultimately brought that one juror around?
I wouldn't necessarily say they were on the fence. I think they just wanted to do their due diligence and make sure that they understood the terminology correct, and they understood exactly what the judge's instructions were in relation to that specific charge.
Again, just thinking about this as a lawyer, right? So one of the jurors was on the fence, the interviewer says, and the juror says, I wouldn't really say on the fence. I would just say they wanted to do their due diligence. They wanted to understand the charge fully. They wanted to make sure they understand the judge's instructions. All 12 jurors should have wanted to do their due diligence. All 12 jurors should have wanted to understand the terminology. All 12 jurors should have wanted to understand the judge's instructions. Now, we have to realize this juror is not a lawyer. He's just answering questions to the best of his ability. He's not lying. He's not trying to. I'm looking at it as a lawyer. That's how I'm breaking it down. If I'm a defense lawyer, I'm using that line. I'm saying, see, 11 of those jurors were biased. 11 of those jurors made this trial unfair. 11 of those jurors is the reason why I need a new trial. That's what I would argue if I was the defense attorney. Now, if I was the prosecutor, I would say the other 11 jurors already understood it. The other 11 jurors already felt like they did their due diligence, and this one juror was just a little slower and wanted to look through things again, which is totally fine and doesn't merit a new trial. So again, there's two ways to look at just about every sentence this guy says. We don't usually get into the minds of jurors, so this is fascinating to see what jurors think, what jurors feel throughout the process, and what really convinces jurors to go one way or the other.
What was the tipping point for you as a juror? Was there a piece of testimony, a piece of evidence after you saw it or after you heard it, your mind was essentially made up?
I think after Dr. Chauvin's testimony, I think the way he broke everything down, but still kept it very scientific, that was kind of the point where I was like, okay, I don't know how the defense comes back from this.
So he asks him, the interview asked the juror, what changed your mind? What really brought you around? What was the key piece of evidence to you? And he said Dr. Chauvin testimony, the expert testimony. And this was one of the things we knew it was going to flip on. What was the reasons that George Floyd died? Was it from this or was it from that? There was competing experts, right? Well, he basically said, I believe the prosecution's expert hands down, and I knew the defense wasn't going to be able to come back from that. Again, fascinating as a lawyer because we never understand or we never know if the jury's going to understand what our experts are saying. But he said it perfectly, what we always want our experts to do. Break it down so lay people who aren't doctors, who aren't lawyers can understand what you're talking about while still keeping it scientific and true and accurate so you can explain what you need to explain in the expert way, but break it down. And that's exactly what he said. He made it simple for us while still keeping it scientific. So they believed that he was an expert. They believed he knew what he was talking about, but he made it easy enough for them to understand to where they were like, it's over after we heard this.
As you know, there was a fair amount of talk about whether Derek Chauvin would have testified or should have testified. Do you think that him testifying would have made a difference, Brandon?
I don't know if it would have made a difference or not, but I don't think it would have hurt. I mean, we found him guilty on all charges, so I don't think it would have hurt. It probably could have only helped him at that point.
A lot of folks were somewhat surprised.
So this is a very touchy question. And if I was the prosecutor, I probably would have asked this interviewer not to ask this question. I realize he's trying to give the people what they want as an interviewer, but I think we all want to kind of protect this verdict. We don't want to open up doors for appeal unnecessarily, right? But we do want to make sure it was a fair trial. So again, at the same time, you ask this question, you get the truthful answer. And if the truthful answer really shows that it was an unfair trial, then it is what it is. But this juror did a fantastic job answering this difficult question. So the interviewer asks, he didn't take the stand. Do you think he should have? And if the juror would have said, oh, that's exactly what all of us were talking about in there. He didn't take the stand. He must be guilty. That's why we convicted him, because he didn't take the stand. Boom. The verdict is gone because they're holding he has the Fifth Amendment right not to testify. And if that's the reason that they convicted him, then this verdict is no good. You cannot hold that against him. The judge instructs you that you can't hold against him. The law says you can't hold it against him. So if he said that, absolute huge problem and red flag. But instead, what does he say? He just makes a logical, common sense observation. Couldn't have hurt. We found him guilty on all charges. It's not like anything he said could have made us say guilty twice. You know, we said guilty. So if he would have testified, maybe it would have gone better for him. I don't know. I can't go back in time and figure this out, but I know that it couldn't have gotten any worse than how it did for him. So that was a great answer because that's just logically speaking. He lost, right? So if he would have testified, maybe he could have won. We don't know. It adds an element that we don't understand and we don't know how it would have affected the case. So I can't say for sure, but I don't think it could have made it any worse, right? There's nothing worse than being guilty on all charges. Great answer. Intelligent answer, and not an answer that gets anybody in trouble, not an answer the defense can really use in this appellate process.
A lot of folks were somewhat surprised at the speed with which the jury came back. All
right. So after an absolutely fantastic answer, a home run, I think this is a swing and a miss, right? So the interviewer asked a good question. A lot of people talked about how fast you guys came back. 4 hours for this intense trial, for this long trial, for this serious trial, for these serious crimes. And only 4 hours and you guys were back. And he smirks. If I'm the defense attorney, I'm using this screenshot saying, they knew. This guy's laughing about how short of a time it took. And just wait, he's about to say it should have been even quicker. I'm using this as a defense attorney in my appellate argument to say, this guy made his mind up before he walked in the room. He didn't give Derek Chauvin the presumption of innocence. He was going to say guilty no matter what the evidence was. Look, he's laughing at how long it took them. He said it, and he says it should have been shorter. For this serious of a crime, a man's life. That's what I would say if I was the defense attorney. Now, if I'm the prosecutor, I'll just say, the evidence is overwhelming. He says that too. It was obvious evidence is overwhelming. When the evidence is overwhelming, you don't need to sit there for 3 days if you all know the answer. So again, something that cuts both ways. I just wish he would not have smiled like this and maybe would have worded this a little bit differently.
Almost seemed as if you guys went in there, you elected your foreperson, you went around the table, you said your piece, and then you voted. Is that a fairly accurate assessment or no?
I thought we should have came back a little bit quicker, actually. But the time we did spend was time where we were just kind of going over the details again, making sure everybody was on the same page and just clarifying. So, yeah, for the most part, we did go in and come straight out. But I thought it should have been quicker, actually.
Why? Why do you think it should have been faster?
Just because I thought the evidence was overwhelming that he was guilty, in my opinion. I thought it was a no-brainer. Like I said, after Dr. Chauvin and all the other witnesses and all the evidence, I mean, I didn't see any reason why we should have took longer than an hour.
What did you make of Derek Chauvin's demeanor?
Again, he says, I think we should have gone quicker. Why say that? I just don't understand why. I guess he wants to show that, like, slam dunk, drop the hammer, overwhelming evidence. I just don't know why he said it should have been quicker. Most people understand and realize that 1 hour, it's almost impossible to have 12 people. 12 people couldn't pick a restaurant in an hour. They definitely couldn't pick a movie, but they're supposed to pick 3 verdicts on 3 criminal counts of murder in different forms of murder in an hour. I just don't think, while he was very logical and made perfect common sense on his discussion about whether or not Chauvin should have testified, this doesn't make sense to me. This was a swing and a miss. His whole description of the timing of the verdict, it was almost seems like a brag. I don't know. I personally, when you're doing your civic duty and you take this stuff seriously, he should have just said, 4 hours is a long time. Sit and do anything for 4 hours. It's a long time. We discussed everything. It was quick because the evidence was overwhelming, but it was a long time for us to sit there and discuss everything. Saying that it was an hour and kind of being like flippant about it and how, oh yeah, all Dr. Tobin and all the witnesses, all the evidence, guilty, overwhelming. It just wasn't my favorite way to answer the question, and I think kind of opens the door for some things for the defense. That's all. I'm not saying that he's lying or anything like that, because he did say in those 4 hours we went over all the details. That's important. That's what you're supposed to do. That's why you can't do it in an hour. You know, he's kind of contradicting himself, because I think they did the right thing, taking 4 hours, making sure they went through all the details. If the verdict would have come back in an hour, again, I think the defense would have more arguments, because they'll say they didn't even discuss anything. They all knew it was guilty before they ever sat on this jury, because we should have been in a different venue and they should have been sequestered, and boom, there's our motion for new trial. So we have to be careful with this stuff. We have to make sure we're protecting the record, we're protecting the verdict, so that nothing comes into this trial that shouldn't be there.
In the courtroom throughout the trial?
Yeah, so, I mean, from my perspective and the angle I had, it looked like he was very confident the first week and a half. And I personally could see the confidence kind of deteriorating from him and a little bit from his team of attorneys. As the more and more witnesses came up, it just seemed like they were deteriorating their confidence, and it was just getting lower and lower and lower as the trial went on.
As you know, the entire world was watching this trial. Did you feel a greater sense of pressure as a juror, knowing that?
Here's the ticket. So we're going to pause this right here. This is what we've been waiting for. This is their best argument, the pressure that this jury felt. And let's listen to his answer.
No, not at all. I mean, we all knew coming in that everybody would be watching, but I don't think there was any pressure. And there's so much stress within the courtroom. We didn't even have time to think about anything on the outside or any of that. I mean, just being there alone and witnessing what you're witnessing on the videos and listening to all the people, that alone is enough stress. You're not paying attention to anything else, really.
As the president said before the verdict came down, I want to make sure I get this right. President Biden said, quote, "I'm praying that verdict is the right verdict," which I think it's overwhelming in my view. I wouldn't say that unless the jury was sequestered now. Did the president's comments influence your decision at all? Any other juror's decision?
I didn't even know what the comments were until just right now when you just said them. That's how far removed I've been from the news. I mean, even still.
Okay. So first, he says, absolutely not. There's so much pressure in the courtroom. We had to make these big decisions again, which goes back to why it shouldn't have only taken an hour to make this verdict. But There was so much pressure. There was so much stress. They felt the weight of the decision because it was murder charges, not because of the outside pressure. And then the interviewer says, well, let's talk about what President Biden said. And President Biden started by saying, I know the jury's sequestered, or I wouldn't say this, but I hope they come back with the verdict that the evidence overwhelmingly points to. Smart by President Biden. Not so smart other politicians that were commenting during the trial when the jury wasn't sequestered and the jury could read and hear exactly what they were saying. So again, that puts more of a highlight on the politicians that made the mistake of making these comments and putting this pressure on during the trial, and highlights how President Biden kind of did the right thing. If you're going to have to say something about it, wait till they're sequestered so your comments can't have an effect on the verdict. And again, can't be something the defense then use to make an appeal. Biden knows how that works. So you don't want to set that up so where you're setting them up to help them with the appeal, right? So then he talks about how he's been so removed from the media, so removed from watching TV, so removed from the news that he didn't even know what those comments were still to this day, even weeks after the trial. Perfect answer. I mean, this is just a normal dude. This guy's like totally normal. This jury's your average jury, your average, United States citizen that's going to sit on a jury and make this decision. So he's answering these questions like a normal guy. I don't know if he was prepared for these. I don't know if he was coached or told beforehand what these questions were going to be, but he's answering them honestly and openly, and he's just saying, I didn't even know what the comments were. None of that came into play. Now, whether people bring their own experiences and thoughts and feelings into a jury room as a juror, that's why they make those decisions, how they make those decisions. That's fine. But he's saying nothing else affected him or the other jurors. Right now, he's kind of answering for the other jurors, saying, we didn't feel that pressure. We didn't know what was going on. We were stressed and focused about what was going on in the courtroom with these serious charges. Great answer. Really doesn't open many doors for the defense to use any of this in their appeals.
Because it gets covered so much. So I didn't know until you literally just said that now what the comments even were.
One more question, then Al's got a question for you, Brandon. The sentence, as you know, at this point, he's facing up to 40 years for second-degree murder. What do you think he should get?
Well, that's not up to me to decide. We came up with the verdict. I feel like we came up with the right verdict, and now it's time for the judge to do what he does.
Okay, so another just spectacular home run answer. Because if he comes and says he should get 40 years, he should get life, he should be killed, the electric chair, whatever, if he does any of that, if I'm the defense, I say, see, Judge, like these people wanted to crucify him before this thing even started. But no, he does. He shows that he paid attention to what the law was. He paid attention to what the judge's instructions were. The job of the jury is to come up with the verdict. Don't think about the sentence. The job of the judge is to come up with a sentence. So this guy says, we did our job. We came up with the verdict. I think we came up with the right verdict. Now it's time for the judge to do what he does. And what the judge does is decide what the sentence is. Perfect answer, home run answer, opens no doors for appeal, in my opinion. So just to highlight what is so important and what is the biggest deal and the scariest part of these appeals and motions for new trial for the prosecution, we're going to ask him just one more time a similar question to what we've already asked.
Hey, Brandon, after the verdict, there were some in some corners of the media said that you guys were already predetermined what you were going to do, that you felt the pressure going in, and that if you didn't come up with a guilty verdict, that things were going to go badly, that you were already determined to do that. Would you lay that to rest right now?
Yes. I mean, to me, that's just so dismissive of the entire process. So we're everyday civilians that put our families, our jobs, and our days aside to serve justice. I mean, so we all walked in with an open mind, and we left out with a guilty verdict. But that's literally how the system is, and that's how it works. I mean, we walked in with an open mind, and we were waiting to see. We did our due diligence to see what the defense was going to come up with. We just felt like the evidence was overwhelming for our verdict. It had nothing to do with pressure from anywhere. All right. It's just a decision that we came to, and that's what the jury system is there for.
Brandon Mitchell. Brandon, we so appreciate you taking us inside that jury room. Thank you. Thank you for your time this morning. Thank you for your service as well.
Yeah, really fascinating.
Absolutely. Thank you.
Brandon, thank you.
Another very good answer. I won't say home run because there are some things I can pick apart in it a little bit. But again, he says, no, we came in with an open mind and the evidence was overwhelming. Now, if I'm the defense, I will say, he said they came in wanting to see what the defense was going to do, what evidence the defense was going to show. So he said we went in with an open mind and we wanted to see what the defense was going to come up with. Play that clip one more time, just that little part.
But that's literally how the system is, and that's how it works. I mean, we walked in with an open mind and we were waiting to see, we did our due diligence to see what the defense was going to come up with. We just felt like the evidence was overwhelming for our verdict. It had nothing to do with pressure from anywhere.
That's not how the system works. The defense can sit there and do nothing. They have no burden of proof in a criminal case. What he should have said is, we came in with an open mind and we wanted to see what the prosecution was going to show. Once they showed it, boom, it was overwhelming and there was nothing the defense could do to change our minds. We knew it was a guilty verdict once we saw the prosecution's evidence. But instead, he flipped the burden and he said, we came in wanting to see what the defense was going to come up with. What evidence the defense was going to do. Was the defense going to hold their burden? So if I'm a defense attorney, I'm picking that apart saying, they came in with a backwards burden. They came in wanting us to prove innocence, which is not our burden. They didn't put any burden on the prosecution because they already knew what they wanted to do when they came in. If I'm the defense attorney, that's what I'm arguing. And I think that's why it wasn't a home run. Now, besides that, he says, don't be dismissive of the judicial system. You can say everybody's got their mind made up before they come in and make a decision. But we put our lives on hold, our families, our jobs, everything on hold to be a juror and serve justice. And that's what we did for weeks. And we came up with this tough decision, but we think we got it right and the evidence was overwhelming. Great answer. The one little part I'd pick apart is just him putting that burden on the defense. So, after this interview in its totality, I do think the defense is going to use some stuff from it to show their points because it kind of fits in with their points, but he slammed the door on some of the biggest arguments. He slammed the door on the media pressure. He slammed the door that the jurors should have been sequestered or change of venue as far as what his answers were. And again, we have to take them as what they are. He's telling the truth here, and he's saying that none of that stuff affected them. So this, I think, makes it less likely that Derek Chauvin gets a new trial. So there's one more important aspect to this entire situation, right? So we just heard this juror's interview and what he had to say about the process, what affected them and what didn't. But what we didn't hear about in this interview is that this juror was seen at an MLK march in 2020 before the trial with a BLM hat or shirt on or something expressing BLM with phrases regarding George Floyd on his person and in and around the march. So is this something that should have disqualified him? Is this something that's going to create an issue for appeal or create a new trial for Derek Chauvin? And the answer is it depends. It depends on whether or not he was honest and forthcoming about this situation. The fact that he went to the rally does not disqualify him to be a juror if he can put that aside and still be fair and impartial in this trial. Just being at that rally does not make him somebody that can't be a juror. So the question is, when he was asked about his thoughts and stance on BLM, was he honest to the defense attorneys? Did the defense attorneys ask him point blank, have you ever been to any of these marches? Have you ever been to any of these rallies? We don't know that, or at least I don't know that as I sit here. And we don't know what his answer was. If he was honest and he said, yes, I support BLM. Yes, I've been to the marches. I went for the I Had a Dream speech. Yes, I went to support MLK. Yes, I went to be around a lot of other black people because it was something great to be a part of. Those are the quotes I've seen now as to the reasons he went to that, and he still thinks he can be fair and impartial and it didn't affect his verdict at all is what he says. So did he say the same things to these lawyers during the jury selection? And if the answer is yes, he said all the same things and he let them know about it and they still picked him, then it's not an issue at all. It's a moot point. No issue for new trial. But if he lied and said, I've never been to any marches, I've never worn any BLM shirts or hat or anything like that, I didn't know any of these quotes that had to do with George Floyd, like I can't breathe or somebody kneeling on somebody's neck or anything like that, if he said that I've never participated in any of this stuff that had any BLM stuff at it, and he lied about all that information, that is absolutely an issue that could bring about a new trial. It's going to come down to whether or not he was honest and forthright in jury selection. That's an age-old issue for appeal. If jurors lie to get onto a jury and they are biased and should have not been on that jury and they were, boom, that's an issue for appeal. It's an issue that could create a new trial. So we've got to keep a close eye on this. The defense attorney is going to for sure order all of the record. So once they get the record, every single word that every one of those potential jurors, every word the lawyers say, every word all the witnesses said are typed down and in black and white for us to read. So we're going to hear whether or not this juror lied during jury selection and got on this jury when he should not have been because he wasn't telling the truth, even though he swore his oath to tell the truth. So this is something that could be important going forward. We're going to have to keep an eye on it. Let me know whether you think he should be on this jury if you found out that he was lying during the jury selection process. Let me know if you think it affected this verdict. Hopefully you guys enjoyed this video. Let me know what you think. Let me know if this juror has changed your mind and whether or not you think he's going to get a new trial and why in this case because of what this juror said. And also, 90+% of you are not subscribed to my channel. So make sure you subscribe so you can get the future videos. Like this video and we'll be back with you next time.
Thanks for watching this episode of The Lawyer You Know. If you like this content, please share it with your friends. Make sure you subscribe to our page and like our videos. If you want some interaction, get in the comments and we'll be sure to get back to you. If you want to know any more information about our firm or this page, you can find out in the description or visit tragoslaw.com. We post multiple times throughout the week, so make sure you hit that bell so you can get the notification and not miss out on the next episode.